And this next case is State versus Grether. All right, counsel, same rules, 15 minutes each. The appellant may have 5 minutes to keep for rebuttal. It's up to you, just let me know. And we're ready to proceed.
Give me just 1 second.
You're fine.
Change gears, I apologize.
Everybody's going back and forth between appellant and appellee today, so it's confusing.
We're on the right side.
That's why we have the little placards there now.
Morning again. I would again reserve 5 minutes for rebuttal. May it please the court, I'm Alan Medvick. I'm here on part of the defendant and appellant, Brandon Grether. Mr. Grether has raised 2 assignments of error, well, maybe articulated as 3, but essentially 2 issues argued 2 different ways. One regarding the presentation of the inadvertent disclosure of prior offensive acts by the defense counsel, by Mr. Grether's trial counsel, and as well as an improper jury instruction given regarding the allegation of digital rape in this matter. As to the first issue regarding the video, which, or I believe it was an audio playback that disclosed that Mr. Grether had prior sex offenses. I think it was clear, I would argue that it was an abuse of discretion not to declare a mistrial. The gravity of the offenses here that Mr. Grether faced, the significance of and prejudicial value of that statement as compared to any benefit that could have been gained, as well as combined with the acts in the record of his own trial counsel to keep that evidence out. It was clear that they were not, I believe the trial court basically says that they reported their own error and they don't get to benefit from that. And that's not generally, and I understand that that's an accurate statement of law. I don't believe that's an accurate application of that law. That in this case, this was not sitting on an error to try to create an appellate record. This was a clear inadvertence that the trial counsel attempted to address almost immediately. And it was early in the trial. I believe it was the first witness on cross-examination. It was significantly prejudicial, especially at that point, coming, I believe, just after the child victim had testified and on cross-examination. And I think at that point, the balance of equities, the concerns about judicial economy, and bringing finality to cases far outweighed by the concerns about making sure that Mr. Grether got a fair trial and was given every benefit by the state to have a fair trial and have his matter heard correctly.
Counsel, the state indicates that counsel, after playing the audio, actually debated whether or not the court could get a curative instruction, because the court offered to give a curative instruction. So how can we say that it was prejudicial when counsel, even at the time of trial, didn't even know if the jury had heard it, because he declined a curative instruction?
And I believe the judge heard it, and she's actually further away than the jury. The odds on the judge having heard it, the prosecutor having heard it, and all 12 jurors having not heard it is unlikely. And the decision to not give a curative instruction, which has the as I think you know, has the potential effect of bringing something to the attention of those jurors who may not have heard, and of bringing it back to attention and actually having an opposite effect. I understand it's a trial decision, but I don't think this is about, that could have been unwrung at that point, that's such significant information. I don't know that curative instruction would have been of benefit. As practicing jurists, you know the reality of that.
Well, and I understand that's a strategic decision, but at the same rate, the way I understand it, and we'll read the transcripts and everything, obviously, thoroughly, but the way I understand it, it wasn't so much that they were saying, should we make a tactical decision, not emphasize it, or did the jury even hear it?
And I believe that there's every indication that the jury must have heard. It was certainly presented, and I don't know that we can, here on appeal, rely on the jury having not heard it as a.
And that audio is not part of our record.
I believe it is. And I will, and I think both the redacted and unredacted version, because I believe the properly redacted version went back to the jury, but I believe the unredacted version should be part of the record. I will verify because I want to make sure that's here. But that aside, the alternative to that is that this was an act of ineffective assistance of counsel, that they had gone to these great lengths. It's almost the two prongs for ineffective assistance are deficiency and prejudice, and I think even the trial counsel at this point would recognize that the presentation of information they had been trying desperately to keep out of the case would be below the standard of care. And secondly, I think that information would be clearly prejudicial if presented to the jury. So in that regard, I think even as an alternative, this was an ineffective assistance issue, which brings us to the second issue, which is concerning the jury instruction regarding digital rape and the language that any penetration of the vulva or labia constituted digital rape under current law. And that, again, we're in, and as the prosecutor points out in the brief, I'm arguing these issues in the alternative. I understand the nature of that. The Melendez case out of this district and the Nieves case following up on that indicate that constitutes an instruction under that is what the trial court relied on in giving that instruction, I believe. And to be clear, while the other claims here, I believe, are at an abuse of discretion standard or ineffective assistance, regarding the admission of the video, I think that's an abuse of discretion standard. I think this is a de novo review for your consideration here as to what the jury instruction should have been.
Before we get to that, I think, correct me if I'm wrong, but I believe the state's arguing that it really doesn't matter in this case since the victim testified that even the definition of rape that you are proffering, that happened.
The defendant is due an accurate and proper instruction as to what the law is. And the court, the state does not get to assume what the outcome would have been without that incorrect instruction. The evidence, if that is the case, this is an issue of mistrial and they need to go back and try this again with the proper instruction. They don't get to simply assume that guilt. They found him guilty according to the law as read to them, and that's the verdict the jury reached. And the law that was read to them is not an accurate statement of the law. So to call this harmless error is to make an assumption that is not there. Because you're presuming unanimity that is not present. I'm sorry.
No, I was just going to say, I'm listening to your argument and I'm thinking about a case in the Supreme Court where my decision in this court was reversed because the court said the jury instruction was clearly wrong, but it didn't matter.
And that's my point. that
I think that's saying the opposite.
you're going against me.
Yeah.
Well, then,
Because you're saying that even if the jury instruction is wrong, I mean, you don't have to establish prejudice, it's automatically
Yes.
prejudicial. I'm not sure that's what the law is, that's what I'm trying to say.
and regardless, I do believe that based on, in this case, even stopping short of that, okay, in this case, I believe that it's clearly prejudicial because in this case, I believe that the whole of trial counsel's argument and their whole approach to this trial was to establish that this was gross sexual imposition and not digital rape based on the interpretation regarding the difference between the vaginal opening and the vaginal cavity as has changed in the law and
With the statute.
in the statute, yes. And as had been interpreted in the In re DH case out of Franklin County, which is referenced in the brief. And so in this case, there was clear evidence and clearly argument and evidence presented contrary to that finding. And I believe that there would be prejudice and that the trial attorneys worked hard to reach that goal, which brings us to, again, if that is not the case, if the law under Melendez is the law of the court, then the trial attorneys basically slow-rolled their client into a rape conviction. And there's evidence in the record of that being prejudicial, even in what would normally be a PCR petition.
Counsel, I want to warn you in your rebuttal time, but I'm trying not to interrupt you, but.
No, I'll wrap this thought up, that in the sentencing hearing, which is part of the record, there's clear evidence of plea offers that stop short of a life sentence. And so Mr. Grether, based on the trial counsel's actions, was foregone possible remedies that would have had him short of the 25 to life sentence that he received. And so the deficiency in that record would be clearly prejudicial, and I'll save the balance of my
Thank
time.
you. You proceed.
Thank you, Your Honor. Good morning again, and may it please the court, I'm Jacqueline Corrigan for the state of Ohio, this time the appellee. And really, Your Honors, there's one question that this court has to answer again in this case, but this actually is dispositive of all three of Mr. Grether's assignments of error. And that is this: is there a reasonable probability that Mr. Grether could have been acquitted if any or all of these claimed errors had not occurred? The answer to that question is no. Now, why that is because no matter how this trial court set the boundary, or no matter where it set the boundary between gross sexual imposition and an actual digital rape, the victim in this case said that Mr. Grether crossed it. And it doesn't matter where the line is set per this court's decision in Melendez or in DH. The victim in this case testified, and I hesitate, but I'm going to have to say it. She testified that Mr. Grether inserted his fingers into the same place where she now inserts a tampon when she has her menstruation. Regardless of whether that's a vaginal opening or a vaginal cavity, that's in the vaginal canal, and no matter where you define the threshold for rape, that crossed that line. With that testimony, it didn't matter whether counsel inadvertently exposed Mr. Grether's prior convictions. It didn't matter whether they understood the impact of Melendez on the impending jury instructions, or what the state had the burden of proof, or burden to prove. It didn't matter with that testimony. And the test, by the way, for under Strickland, with respect to counsel, the test for prejudice is not whether the evidence that came in is prejudicial. It's, did this evidence change the verdict in this case? Would that this verdict have been different but for the introduction of this evidence, or but for the inadvertent exposure of the priors, but for counsel's misunderstanding as far as Melendez. It's not going to make a difference in this case.
Counsel, we often don't say, it's often raised, but we often don't say cumulative error.
Correct.
But here, you have the jury supposedly hearing that he was convicted previously of sexual offenses. And then the appellant is arguing that the wrong instruction was given. So all these things, when you take them together, could that not have changed the outcome of the trial?
Not in light of the victim's testimony, because what she testified to made everything else, it decided the issue as to whether he had committed rape or whether there was any kind of argument as to whether it was gross sexual imposition. Furthermore, I would remind the court that cumulative error wasn't raised in this case, and we haven't briefed it. But this is not the appropriate case for that. This is as I said, this is a case where Mr. Grether can't prove that his counsel's performance, even if it was deficient, and I'm not arguing it was, but even if it had been deficient, didn't prejudice him.
Counsel, what's in the record regarding the trial judge's reasoning for not declaring a mistrial? Was it about whether people could hear things, or was there some discussion on the record?
There is some. I don't remember the specific discussion as to whether it parsed out to be a discussion about whether it was invited error, or whether the jury could actually hear it. But I do recall that there was some discussion about whether it was invited error, even though counsel had said it was inadvertent. But really, even with the mistrial, there again, with the victim's testimony being what it was, there wasn't any abuse of discretion in denying the mistrial, because mistrials, of course, are extreme remedies, and you can grant them where there is material prejudice to the defendant, or where there's no. Well, actually, I should flip it around. Denying that is okay where there's no material prejudice to the defendant, or there's overwhelming evidence of the defendant's guilt. With the victim's testimony being what it was, we do have that overwhelming evidence of defendant's guilt.
What's the state's position if the record reflects that the trial judge said this is invited error, no mistrial? Is that correct? Is that a correct ruling? In a circumstance such as this?
I would still say that the state's position would be that there's still no abuse of discretion. However, if I were the appellate counsel dealing with this, or if I were the judge's judicial attorney, I would be saying, I don't know if this is actually, if it fits really squarely with the concept of invited error, because this may have been an oops, a mistake, which is what counsel had said it was. It wasn't something that they had used as a tactic, which is usually where you see invited errors, where counsel uses a trial tactic, and then later on appeal says, oh, by the way, that was error, and the court then rightfully says, no, you invited that error. This was just something that happened. So I'm not sure that invited error quite fits, but in light of the fact that this occurred right after the victim had testified, like I said, it's not something that caused prejudice to the defendant. Plus, you have to keep in mind that the tape of this interview that was played isn't in the record. It was not made an exhibit. It wasn't introduced into the record. So we really cannot know whether this was a fleeting reference by the victim's mother to Mr. Grether's prior convictions. We have no way of discerning what the jury may have heard. All we can do is speculate about it.
So would it be the state's contention that the decision not to ask for curative instruction was tactical?
That I would, because there is in the record the counsel telling the court, we have to decide whether we're going to do this because we're not sure how fleeting this fleeting reference or this reference to his convictions. We're not sure how the jury perceived it, if they perceived it, and we're not sure whether we want to focus attention on it in the jury's mind by asking for a curative instruction.
I thought I heard him say that the redacted version went back to the jury. Of the jury instruction, of the redacted.
Yeah, I heard that too. When I had checked the record, I did not see that it had been in the record, but I could be wrong on that. But it wasn't made I do know it was not made an exhibit.
So you're saying it's not before us regardless?
To say that it was definitely heard by the jury would be speculative by all of us, including this court, because we don't have it in the record. That's what I'm saying.
Well, I guess I'm wondering how it becomes a tactical decision, because to try to make that a part of the record would be trying to invite enough error for a mistrial on defense counsels. Do you understand me? They can't necessarily profit and not be cloaked in you're just trying to mess this up so we can't have a trial here.
Like if they had actually made an exhibit,
Right.
sent it back to the jury, unredacted, that would be, I'm having a little difficulty wrapping my head around that one too, Your Honor.
Suppose there might be other ways to preserve, but I don't understand how they could have gotten it into the record.
Well, it could be proffered outside, but not sent back with the jury, proffered and asked that the court make it as a court exhibit for the purposes of appeal.
But the state's not disputing that what was on the tape and what was played by accident, correct? Only that it doesn't matter.
Only that it doesn't matter. In light of the victim's testimony, it really does not.
Oh, okay, I'm confused now, because I want to make sure. I know you're arguing it doesn't matter, but you also, I think, argued in your brief that nobody really knows exactly what was said.
Correct.
So if we don't know what was said, we don't know anything about it, whether it's prejudicial or non-prejudicial.
Actually, it can't be prejudicial in light of the victim's testimony. What I was arguing about, it's not in the record, is an alternative, but when it really comes down to it, in light of the victim's testimony, what she testified to is, by definition, by any definition, digital rape. And so,
I understand that argument, but you're not arguing, correct me, if I'm incorrect. You're not arguing that her testimony means that this tape being inadvertently played couldn't possibly have been prejudice. You're not arguing that, just arguing that she testified digital rape. It's a different issue, right?
what I'm going to try to clarify this for myself too, as I say it. What I'm arguing is that the tape could have been prejudicial in the sense that it was certainly harmful to his case, or could have been harmful to his case. I'm saying that it is not prejudicial in the terms that we have to look at prejudicial for the purposes of a mistrial, in terms of, did the introduction of that tape make the difference between a guilty and a not guilty? I think it's the difference between, is this harmful versus is this outcome determinative? And I hope that helps.
So you're saying it's not reversible ever?
Correct. Correct. Finally, because I know I have very little time left, again, concerning the jury instruction. And I understand that appellant is bringing an alternative argument concerning Melendez and the impact of Melendez. But again, even if the court had given a jury instruction that didn't follow Melendez, which is the controlling law in this district, but instead had given a jury instruction that the defendant would have preferred, again, it would not have made any difference in light of the victim's testimony. Keep in mind, though, that there was no objection to the jury instruction as presented before the jury retired, so whether the trial court erred in giving the jury instruction has to be reviewed for plain error under this court's decision in Pinckney. It was a correct statement of the law as, per this court's controlling precedent. Also, other districts in the state have continued to follow the same line of reasoning as Melendez and follow the same definition. But even again, in Judge Hensel, your question earlier, even under DH, we would have had the same outcome because of the victim's testimony. So if there is error here, it is harmless beyond a reasonable doubt. And in addition, it would not invalidate all of the jury's findings, like, for instance, an error in enunciating the burden of proof that falls on the state. So the trial court did not abuse its discretion, and it also did not commit any kind of plain error. So on these grounds, the state of Ohio would otherwise rest on its briefs and thank the court very much. Unless there are further questions, we ask you to affirm.
Thank you, counsel.
Thank you.
As the monitor shows, you have 3 minutes and 45 seconds.
Thank you very much. To the statements of the prosecutor. First, the standard for ineffective assistance is whether there was deficiency and whether there was a reasonable probability of different outcome. It's not doesn't have to be a certainty, it doesn't have to be, but that is the language. There's a reasonable probability that without that error, without that deficiency, there would be a different outcome. And what I have heard the state's position be that the one statement by the victim in this case, that the one statement is definitive of this case, that essentially paring everything else away, every other act, every other conduct, every other witness in this action, every bit of cross-examination, one statement by the witness is sufficient to find my client guilty beyond a reasonable doubt. That has been the essence of the argument she has made here in dismissing ineffective assistance and improper instruction claims here.
Counsel, let me ask you this. If the audio is not part of the record, if we cannot listen to the audio itself, what's your position in regard to that?
And I apologize if that is not part of the record and I misstated my recollection of the record there. And first, I would work to correct that and try to supplement. But secondly, I believe that the responses in the record, the conversations held in the record between trial counsel, prosecutor, and the judge in chambers make it clear that everyone in that courtroom with legal knowledge understood that that was a prejudicial statement and significant. That every statement by two trial attorneys and a judge and a prosecutor are clear in the record that this was a statement of prejudice. I don't think that's a dispute, that this was a deficiency and that it would have been prejudicial to be heard. To that, and regarding the statement that there was no objection to the jury instruction, I believe it's a mischaracterization of the Pinckney case, that in reading that case, I believe that there was no objection prior to the instruction going back. Here, there was objection, there was discussion, there was argument in chambers regarding what the language of that should be, that they would have to reassert that just before the jury instruction, right at the time the jury instruction was read, is not an accurate statement of Pinckney case or law in this district. I would ask you to read that. And finally, regarding and speaking again to the statements of the victim, there was cross-examination regarding that position. There was alternative evidence presented, and the entirety of the case presented in defense was that the actions of Mr. Grether were a gross sexual position. To reduce the entire trial down to one statement is over-reduction, and improper characterization of the evidence presented here. I think there has been evidence, and there's evidence in the record that that these acts were prejudicial, at a minimum, that there was ineffective assistance that led to prejudice to the client, and I would ask this court to remand for mistrial based on those grounds.
Thank you, counsel.
Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides
All captured.
and also released on electronically on our website. So thank you.
Thank you very much.